Understanding that we have a little bit of a different situation with oral argument, I'll leave it up to the parties. It's my understanding Ms. Hamilton will use half of the time, is that correct?
That's correct.
And then the other half will be by Ms. Register? Okay, I'll let you two decide. I'm not going to put a timer on for 7.5. We'll do 15 minutes. You two can decide. And then it's my understanding Bradley Strouse will be arguing?
That's correct, Your Honor.
Okay, thank you. Ms. Hamilton, you may begin.
Good morning. May it please the court, Madam Chief Justice and opposing counsel. I am here grateful for this opportunity to be here and argue on behalf of my client, Marcelino Alvarez-Victoriano, the plaintiff and appellant. We are here today to ask this court to vacate the ruling and order in the trial court and reinstate the plaintiff appellant's dismissal without prejudice. The plaintiff appellant believes that this is the correct outcome of this case for 3 reasons. 1, that there is no conflict between the Iowa Rule of Civil Procedure 1.943, that there are no case law exceptions that apply to this case, and 3, that the trial court did not have jurisdiction to decide any other issues other than the plaintiff's voluntary dismissal. In 2021, the legislature passed a new package of laws that dealt with one in particular that applies today, which is the qualified immunity. The statute goes to 3 parts, which is a questionable change to potentially a Harlow standard, and then the second part, which is really at issue today, is, is there now a higher level of pleading required for these cases where qualified immunity applies, such as a federal Iqbal pleading. The plaintiff chose to dismiss his case without prejudice prior to the defendant appellee filing any answer or responsive pleading. And so under Iowa Rules of Civil Procedure 1.943, the plaintiff had an automatic right to dismiss his case. And that's what happened in this case. The case law that was cited in the trial court arguments, which are the Vennard case, the Muting case, and the Blair case, none of those cases all of those cases, are distinct in legal issues and fact issues from this case. The Vennard case goes to a medical malpractice case that had missed the 668 deadline. This case, so that was after a responsive pleading. Again, does not apply as distinctive from this case here today. The defendants and appellees make an argument similar to the new statute, that's the certificate of merit requirement. I think that is distinctive, and I do think that the Struck case is distinctive from this case here today, because the certificate of merit in that statute is much more detailed in requirement of what the plaintiff is required to do in their case. And the certificate of merit really goes to the evidence in a medical malpractice case and the prima facie evidence of negligence in a medical malpractice case, and therefore the legislative intent can be much more detailed and can be much more implied from the purpose of the statute. The jurisdictional issue that arose from the hearing had much more to do with how the hearing proceeded and was postured once the parties arrived. It was not clear until the hearing was actually taking place that the trial court and judge was going to consider the actual underlying merits of the original defendant's motion to dismiss, looking at whether 670 really did apply to the plaintiff's case. And so as soon as that was brought up, counsel did address that with the court, saying that there was a jurisdictional issue, that as soon as the plaintiff filed their voluntary dismissal, the court was deprived of all jurisdiction to consider any other issues. That can be found in the transcript of the hearing on page 14, lines 2 through 14, and it also was readdressed in the transcript on page 23, lines 3 through 13. Further, if the court were to look at, the statute any further, 670.4a, it could be construed that the legislative intent was to imply a federal standard. And so the federal rules would still also allow a plaintiff a dismissal at this standard, because under the federal rules, a plaintiff would, in a very, very narrow area, is still allowed a dismissal, a voluntary dismissal, and is not required to obtain leave of court before responsive pleading is filed. And so even if the court were to decide that the legislative intent was to impose a federal standard, or that the federal rules were really indicative of the intent, that is, the plaintiff would still have been allowed his right to a voluntary dismissal.
What do we do with the language that the legislature did use that said shall result in dismissal with prejudice, which I think is probably different than a federal rule?
I think that it still can be applied, and it can still be harmonized with 1.943, which is what the current case law is and what current statute says, is it can still be harmonized. A plaintiff isn't allowed an infinite amount of voluntary dismissals. And so there is a point where, then what a defendant could do is a plaintiff is only entitled to 2 voluntary dismissals. And the defendant also could file then an answer and then just file a motion to dismiss. And that could put an end to it. So it's not an issue of infinicy or infinity. I want to be mindful of my co-counsel's time, so I will, if there aren't any other questions, I will defer to the other arguer. Thank you.
Register.
Hi, good morning. May it please the court, counsel. My name is Tessa Register, and I'm here on behalf of the state as an amicus. I really appreciate the opportunity and the time today to speak. The larger the deviation from fundamental longstanding practices, I think the more explicit language of intent we should require from the legislature. And so voluntary dismissals without prejudice have been Iowa law since 1873. So Section 2844 of the 1873 Code authorized plaintiffs to dismiss without prejudice up until submission to the jury. And that rule has been tweaked over time, but since 1873, we've had that right. And I don't think we should eliminate 149 years of civil practice lightly, and I don't think we should do it silently absent a clear legislative intent. And so new section 674A3 is indeed a new review of pleadings. A plaintiff will not get past the pleading stage unless they satisfy at least particularity and plausibility. But that review is not undermined by giving full meaning to pleadings and everything that pleading entails. Pleading is repleading. Pleading is refiling a pleading. And so it's the culmination of pleading where that dismissal with prejudice is going to be done. And so in answer to your question, Justice Oxley, what that does is at the culmination of pleading, which in my view is amended and refiled, we're looking at that plausibility review. What a court couldn't do is say something like, defendant's arguments are well taken, unless the plaintiff files an amended petition within 30 days addressing these deficiencies, it will be dismissed. I see that from time to time. That wouldn't be allowed here, right? If they're standing on the petition, they've given opportunities to amend, the court would have to dismiss with prejudice. They couldn't allow leave to amend. Second, there is no substantial prejudice to governments and defendants in this situation. If a petition is refiled within the limitations period, you were always subject to suit in that limitations period. There is no prejudice. You're still entitled to that viability review. If it's refiled outside of the limitations window, you have the saving statute. And that saving statute is hard to invoke, and that is a meaningful benefit to government defendants. It has to have failed, which in the voluntary dismissal context in Furland is hard to show. And it has to be, the dismissal has to be for lack of negligent prosecution, which is also hard to meet. So that's a meaningful check on being hauled to court outside of a limitations period. But even if it does apply and that you're still being sued outside the limitations period, you're still going to have that viability check. At no point are you going to have to answer or expend any litigation resources until a court has said, yes, this is particular, this is plausible. And I think yesterday this court was discussing a somewhat similar context of the certificate of merit. And Justice McDonald, you brought up the summary judgment analogy, and I think that's right here. I've certainly been in times where I filed what I thought was a winner of a summary judgment motion, real clean, reads like a dream, and then it gets dismissed without prejudice, and it's frustrating. But I'm still entitled to move for summary judgment in the later suit. I haven't lost that defense. And so in the Blair case, we talk about substantial prejudice as something more than just the ordinary costs of double litigation. And we see that in summary judgment. I think we see that here. They filed what they thought was a winner of a motion to dismiss. When they get a refiled petition, they can still file what they think is a winner of a motion to dismiss. We'll have that viability check, and they won't have to do anything. Yesterday, to the extent this court thinks that a medical malpractice plaintiff can dismiss in the face of a certificate of merit issue and they can refile and come back, I think a similar result would be required here if that's what the court finds. But if the court doesn't find that, I do think there are a couple of distinctions that are worth discussing. The statutes overlap in principle, but they differ in practice. And so the goal is obviously a quick and early resolution of insubstantial claims. I think a dismissal before an answer meets any definition of quick. But they actually operate differerly. And so in 147, the legislature created a brand new checkpoint, and it created a brand new deadline. So it's not just that you have to show viability through the existence of an expert, you have to show viability by day 60. And we'd expect you that litigation will happen by day, yeah.
I'm not sure we want to differentiate the statutes, but if I think we do, I think I think the better argument is that you can't use 1.943 under this one, because if you read the med mal statute, it says shall result upon motion in dismissal with prejudice, and it talks about failure to substantially comply. So it's clearly not self-executing. Clearly, the defendant has to do something in order to get the dismissal. Whereas this says failure to plead shall result in dismissal. That sounds self-executing. So doesn't that distinction cut in favor of the argument position of the defendants here?
Because the first part is failure to plead, and that means everything that pleading entails, and that means the way we normally dispose of pleadings, which is a motion to dismiss. When they're creating that new checkpoint, it had to come with instructions because it's a brand new procedure. So it could have just said you have to designate an expert within 60 days. It could have moved up a deadline for a particular set of plaintiffs, but it didn't do that. It created a new checkpoint with instructions. So what happens on day 61? Your suit is subject to dismiss. How do you get it? You file a motion. How's that motion judged? Substantial compliance. What happens if there's no substantial compliance? Dismissal with prejudice. But we don't need those types of instructions here because we're just talking about pleading. This is a review of pleading. So instructions to file a motion to dismiss is unnecessary because we're just talking about pleadings, and that's how we handle a deficient pleading.
Is a plaintiff in this situation entitled to a hearing before the district court would dismiss?
Yeah, it's a circle, right? So if 674A3 does not conflict with the rule, then once it's voluntarily dismissed, it's gone. Then nothing else should happen in the case. How defendants who are aggrieved by that should go about it, yeah, sorry.
If a defendant is challenging this pleading, as in this case, and they file a motion to dismiss for failure to properly plead, could the district court get that motion and say, yeah, I think that's right, dismissed on that day, or is the plaintiff entitled to some hearing or some time to actually fight it?
The rules of civil procedure would govern, which means I think you're given 10 days to file a resistance to any motion, and I think you would be entitled to that. I don't see any reason that our ordinary rules wouldn't apply. I think you're at least entitled to a written resistance to the extent that the judge has discretion to have an oral hearing. I think that's up to the judge. I think they almost always do. I'm not aware of a rule on the top of my head that requires it. Yeah.
Dismiss sua sponte. I think that's part of Justice McDermott's question.
I don't think so. I think you're entitled to 10 days to file a resistance. And dismiss sua sponte, as in without motion from... Oh, that's a great, no, I don't think so. I think this is a pleading, and if they just file an answer, I think they're entitled to decide whether to dismiss or answer. I make that decision all the time. Even if I think it maybe wouldn't survive a motion to dismiss, I might hold off and just choose to answer, and that might confuse a court who's looking at a petition thinking, why don't they just dismiss this? And so I would think they wouldn't sua sponte do it. I think they have to decide whether to answer or move in response to a petition.
The Dara case that allowed the court post-dismissal to award sanctions after a voluntary dismissal.
The Dara case, there really was a situation where that court's authority would be undermined. So if there's sanctions on the table and someone dismisses out, and I believe it was attorney sanctions, if it's refiled, it's possible that attorney won't come back. That attorney might not appear. And so in order to protect that court's inherent authority over its proceedings in its courtroom, we need to make sure that that person is reachable. But here, the issue there is the defendants to not have to face suit for a non-viable petition. If this never comes back, they will never be subject to suit. If they do come back, we will have that viability. So unlike in Dara, we're not concerned that you might not be able to do it. I see my time is up. I appreciate your time. I ask that the be reversed and have it be dismissed without prejudice. Thank you.
Mr. Strouse.
Thank you, Madam Chief Justice, and may it please the court, opposing counsel. My partner, Bruce Getman, and I have the privilege today of representing the city of Waterloo and its officer, C.J. Nichols, in this suit. The fundamental question before this court is whether the clear and unambiguous words of the legislature matter. And the defendants submit that they do, and that all litigants are bound by them. Iowa Code Section 670.4a sub 3 clearly provides that a failure to plead a plausible violation or a failure to plead that the law was clearly established at the time of the alleged violation shall result in dismissal with prejudice. There simply is no other permissible result under the express language of the statute.
The statute self-executing?
The statute is self-executing, absolutely.
District court could sua sponte, even if you didn't move, could sua sponte look at a pleading and conclude that it's not plausible and just dismiss the case?
Question that I hadn't considered before you asked it of opposing counsel a moment ago. We don't have to get to that question in this case, but I think it could because there's nothing left to examine. And in this case, certainly we could because there's no dispute.
To examine.
There's no other evidence to be considered. The only thing that needs to be evaluated is does the petition do these two very simple things?
Defendant waive the fact that it's not plausible?
I suppose the issue could never be raised to the court and might not ever be adjudicated.
A sua sponte question then. Could a district court, without any motion by the defense, sua sponte look at the pleading and say that you've alleged some things, but I don't think it's particular, and so I'm just going to dismiss this case?
I think it's possible. I suppose the issue would become if there was ambiguity or a lack of clarity about whether plausibility had really been met. But in this case, there's no issue that there was no attempt whatsoever to meet those two simple requirements of the statute.
You know, you say simple. I mean, this is all borrowed from the federal system, and there's case after case on qualified immunity. It's a very complicated issue. Last term, the U.S. Supreme Court unanimously reversed 2 federal circuits for misunderstanding, in their view, qualified immunity. You know, some pretty smart judges reversed unanimously by some other pretty smart judges. In the federal system, it's all handled through summary judgment. So this notion that a judge could just look at a petition and is so expert on the state of the law that without the assistance of any briefing or anything, any input from the plaintiff could figure out whether this is a situation where qualified immunity doesn't apply. That seems to me really hard to fathom. I mean, I really wonder about that.
I think those comments are well taken. I would submit that that goes to the prudence of a district court judge choosing to do so, not whether it would be legally permissible.
The most important factor is with prejudice. There's probably a lot of things a court could do without prejudice, and you don't worry about that so much. But the with prejudice is, I think, the angle that is particularly disturbing.
I agree with that. And again, I think that goes to prudence. I think it is possible qualified immunity is without question complicated. And this court itself has struggled historically to determine, given the existence of constitutional torts in the state of Iowa that were recognized in Godfrey, what the appropriate qualified immunity standard should be. The legislature has now spoken to that and has established the statute. There, without question, are parallels to the federal system. But the Iowa system is distinct for exactly the reason that we're here today. In the federal system, you do not have to plead around qualified immunity. In the state system, under this statute, you have...
Let's assume a district court judge, sua sponte, looked at a pleading and said, I dismiss this with prejudice because I don't think it pleads with particularity. Who defends that decision on appeal?
I'm not sure I understand. I mean,
Very odd position to put a district court judge in as an advocate for the defendant to just sua sponte, research the law, and decide, I'm going to dismiss this petition with no motion. I mean, that seems untenable to me.
it goes to the probability of that. I think it's quite unlikely that a district court would do so. And it's an interesting question as to whether the district court can do so. But in this case, there was a hearing.
I'm sorry.
Your discussion about plausibility raises an interesting point. 1.943 very much is self-executing. It specifically says once the plaintiff files the petition or files the dismissal without prejudice, the case is just gone. It doesn't wait for anything from the district court. And that's what I mean by self-executing. How is the statute at issue here self-executing when the legislature could have used language like what is used in 943 to make it self-executing, but it did not, as far as I can tell.
Relates to a question that's come up this morning and that Justice McDonald asked yesterday, which is a key question. How is this statute any different from the summary judgment rule, for example? And there are two key differences. One difference is that 1.943, as compared to 1.981, is rule of civil procedure on rule of civil procedure, if you will. And I think most of us understand the rules of civil procedure to be one harmonized body of law which, where possible, should be squared. And so it's reasonable to say judgment shall be rendered forthwith, or whatever the language of 1.981 is. How do we square that with voluntary dismissal? We've got to still give effect to voluntary dismissal. We have a very different case here. We have a subsequently enacted statute that says shall result in. And you've got Rule 1.101.
That statute was drafted with the legislature knowing that we've had this civil procedure rule in place forever. And so we have to assume, right, that the legislature is drafting with that knowledge, and if the legislature wanted to draft around it, it would do so?
That the legislature did draft around it because the legislature also knew of Rule of Civil Procedure 1.101 that says these rules of civil procedure apply unless a more particular statute prescribes a different procedure.
The key language, according to Ms. Register, and I think she has a point, is not the shall results part, but failure to plead. You have to read failure to plead in the context of the rules in general, which don't mean failure to plead the very first piece of paper you file in court. They mean failure to plead after a reasonable opportunity to amend your pleading, which is customary in court, isn't it?
The legislature could have said that. I don't think that's what the legislature said.
Said failure to plead in the initial petition shall result in dismissal. They could have made it clear one way or the other, right?
I think we have to look at the statute as a whole, and if we look at subsection 4, that provides, contrary to the rules of appellate procedure, as I understand them, a right of appeal on something that otherwise would be a matter of discretionary interlocutory appeal. So in the very next subsection, the legislature, without expressly referencing the rule of appellate procedure, said the ordinary rules of appellate procedure regarding interlocutory review don't apply. You have, if qualified immunity is denied, an automatic right of appeal. And the legislature didn't.
But that's an unambiguous statement, right? I mean, it's not an implied repeal of a century's worth of code and case law. It's a very explicit statement. that's contrary to the rules, so there's no ambiguity. But I want to go back to the earlier point. You said you had 2 points about how this is different than summary judgment. And I'm not sure if you got to both, but my question is, on that issue of the shall language, isn't that really solving the disposition problem? In other words, it's making sure that the district court judge doesn't dismiss a case without prejudice at the time the judge rules. It's not creating an entitlement to a ruling, it's directing the disposition for the judge. That seems to me to be the difference.
My reading, and I submit that the only fair reading of the statute, when the legislature says a failure to do A and B shall result in dismissal with prejudice, we would submit that that leaves no opportunity for any other outcome than dismissal with prejudice.
4, subsection 4, any decision by the district court denying qualified immunity shall be immediately appealable. You just stated that that is an acknowledgement by the legislature, and maybe it's my words, of their awareness of our appellate rules, because otherwise our appellate rules would not normally allow something like that to jump right up. So if there's an awareness of our appellate rules in 4, would you agree with me there's no deference or reference to our rules of civil procedure in 3?
My point, that if this court is going to say, in order to require the rules of civil procedure to yield, or in order to displace the rules of civil procedure, you must specifically call out the rule of civil procedure.
It's almost like they said, in spite of the rules, you can immediately appeal this. They could have said that in 3 too. They could have said, in spite of an 1.943. Couldn't they have said the same thing?
It could have. I don't know that the question is it conceivable that it could have been more clear? I think the question is it sufficiently clear? And I think you can compare subsection 4 and 3 and reasonably conclude that the legislature felt, consistent with the Vernard decision from 1994, that they need not call out the specific rule. This court in the Vernard decision said, we are not going to imply dismissal with prejudice. We're going to require you to spell out the penalty in the statute if that's the result that you want.
Enter an order that was along the lines of your opposing counsel. Do you envision that perhaps every time a defendant would file something pursuant to 670.4a, that the response is going to be immediate withdrawal and a do-over? And in other words, does it kind of gut subsection 3?
That's exactly what it does, and in fact, it's worse than that. The state's position, as I understand it, is that you get 4 bites at the apple before you're required to get it right. You get to file a petition. If you don't get it right, you get to amend that petition. If you don't get it right there, you get to dismiss without prejudice and refile the petition. If you still don't get it right, you get to amend that petition. And even after that, you can ask the court for leave to amend. This court has held that it will not allow litigants to circumvent the intent of the statute. That's Justice Waterman's
of that to the city of Waterloo. Maybe it's the passage of time, but at some point, they're going to be able to test the sufficiency of the pleading in the best form that the plaintiff can present it. You don't have to expend a lot of litigation resources on this. So before anything significant happens, give the plaintiff a chance to tee up their best case. What's the prejudice to the city in that circumstance?
The legislature determined that there is sufficient prejudice to the city. I think the legislature, without question, set a very high bar here. You must plead it, and you have to plead it right. And federal cases and state cases have recognized that the adverse consequence here is frivolous litigation.
The state's position is to the contrary of the city. I mean, the state's view, who's speaking on behalf of the state government, says this is how we interpret the statute. And you're saying it's very unambiguous in favor of the city, but we have an amicus that's representing the state that says the opposite. So it doesn't seem that clear to me.
And, you know, no question gets before this court if it's easy, right? And there are certainly questions to it. I guess what I struggle with is this court in Vernard said to the legislature, if you want to prescribe a penalty, put it in the statute.
In Bernard, we also said if the legislature intended a relationship between 1.943 and 668.11, then it could have said so.
Yeah, and I would submit that it did. It could have been more perfect, but the language in Bernard is section 668.11 doesn't suggest that dismissal is a required outcome. In fact, it makes no mention of dismissal.
And I don't disagree with you. The dismissal with prejudice is what the legislature intended, but it's the timing of it. You were talking about federal cases, and what they've done is that the statute draws in kind of the federal standard under Rule 9B or the Iqbal type of standard. But even in federal cases, it's very common that they allow amendments to pleadings before they finally get to the, okay, you've now put forth your best pleading, and it's still not going to meet that standard. Why isn't that what this statute is doing?
Statute says. Nothing in Rule 8.
No amendments.
Well, there's nothing in Rule 8 or in Rule 9 or in the case law or in Iqbal or in Twombly that says failure to do so shall result in dismissal with prejudice. That is unique, as I understand it, to Iowa law. And so that sentence has to...
That still does, but where does that, I'm still not seeing where in the statute it says you don't get an opportunity to amend to try and meet this standard, and then we're going to dismiss with prejudice.
A result other than dismissal with prejudice.
It would be, you amend your pleading. We're still only looking at the pleadings. You're allowed to amend, or in this case, you're allowed to dismiss, and then we just start over. You get to dismiss once, and then we start over. But ultimately, aren't we still looking at the pleadings, and that's what the statute is looking at, is just the pleadings?
My time has expired. I'm happy to respond if the court would permit. The legislature chose to write a sentence that is different from federal law. That sentence has to be given meaning. And if that sentence means you get 4 shots before you're held to account, that sentence is rendered meaningless and it's read out of the statute. So for those reasons, we would ask that this court give the language that the legislature chose meaning and permit the only permissible outcome in this case shall result in dismissal with prejudice.
Let's assume that's right, and that Judge Dalrymple was the judge. At minimum, and correct me if I'm wrong, doesn't there need to be a hearing or a ruling on the sufficiency? It seems like what the court did here was just say, yeah, you're entitled to dismissal with prejudice, but I'm not sure if at any point there was actually a ruling or order that even said the pleading was insufficient. So at minimum, doesn't that need to happen? And there has to be a ruling for us to be able to review whether the district court was right in determining the sufficiency of the pleading? I mean, that seems at least an error, even if you're right.
That would be the case, certainly. In this case, it is not. If you look at the judge's order setting hearing, it made very clear that all issues were on the table for this hearing, and that whether that was the case was going to be addressed. And I believe the plaintiff takes the position that there is no dispute that their petition is deficient. You know, the argument on the motion to dismiss was the rule doesn't apply to us because you can't apply it retroactively and all those sorts of things. And the court resolved those issues. So in this particular case, there isn't any dispute as to whether the pleading is sufficient. It is agreed that the pleading is deficient.
That's abnormal. I didn't see that very often where the parties agreed that one party's pleadings are abnormal. In the realm of most cases where one party is going to stand by their pleadings or at least be asking for an opportunity, wouldn't it be savvy for every attorney who's a defendant on a case like this to just automatically file this sucker and they're going to get a dismissal with prejudice, no hearing? What a great way to get rid of a case. How can there not be a hearing?
There should be. And again, that goes to prudence, I think. I think there should be a hearing. And if there's a question about whether those pleadings are sufficient, that ought to be heard. But no one's denying the plaintiffs a hearing. The plaintiffs don't want to have that hearing because they lose on the merits, right? They want to avoid that statute. And that's what the defendants have a problem with and this court should have a problem with. Isn't the defendants sort of ambushing someone or beating them to the punch on something? The defendants welcome a hearing on the merits of that. But if the plaintiffs want to avoid that hearing because they know their pleading is deficient, that's what's inconsistent with this statute. Thank you.
Ms. Register, are you going to be giving the reply?
Hi, thank you. I want to start with whose interpretation serves the statute. And I think it's the plaintiffs and I think it's the states. I think their interpretation actually does a disservice to the statute. I have a very strong interest in this plausibility standard being meaningful and thorough. I want courts taking a hard look at whether this petition is plausible, and I want that to mean something. And the concern is that if we adopt this gotcha tripwire approach and eliminate silently these longstanding practices and a one-and-done petition, a court is going to be looking at perhaps a petition that might be viable in terms of claims, but because of lawyering is perhaps deficient, and that's a harsh and potentially unjust result. And the result is that maybe they take a weaker view of plausibility to avoid an unjust result. That does not serve the state, that does not serve the statute. I want that plausibility review to be meaningful. And I think the best chance of that is knowing that when it comes in front of the court, the plaintiff has had every opportunity, all the interests of justice require amendments they're entitled to show plausibility. And that way the court won't be afraid of an unjust result. It can take a hard look at plausibility, and at the culmination of pleading, there's nothing there, it can be dismissed, there's no risk of an unjust result. And I'll use an example. In federal court, I was sued in state court, I removed it to federal, they resisted, they tried to remand, I resisted that, I moved to dismiss, they resisted, they tried to amend, I resisted that, they ended up amending, I moved to dismiss, they resisted, I replied. I was like 7 briefs in, and it was dismissed at the end of it, and that was it. And the entire time I'm doing that, it's me and Westlaw. No officer was taken off the street, no employee was taken away from their desk, and there was no interruption in government services because I was taking all facts as true. And when we talk about the burdens of litigation, the case law distinguishes between the lawyer-driven aspects of the case and perhaps the client or discovery-driven aspects of the case. You know, I'm not going to force, people to engage in discovery and stop what they're doing and do depot prep with me until there's a threshold view of plausibility. And I think that's really important. And so, 4 bites at the apple, I've had more. I don't think that disserves the statute because I want that plausibility review to be meaningful. And in terms of the lower court order here, I think what the court said was like they just agreed with the defendant's arguments. It's kind of a summary approval. I know in federal court there is a standard that when you're ruling on qualified immunity, you have to do a reviewable ruling, something for the court to look at. That's just federal dicta, but that is something to consider embracing. And those are the points I want to make. So unless anyone has any other questions, I think the case, sure.
And based on what we said in Bernard, where we allowed the voluntary dismissal under 668-11, that deadline case, because the statute itself didn't refer to a right to dismiss, certainly not dismiss with prejudice. So now they've added that to 670A, 4A. So how do you get around Bernard?
What happens beforehand. You blow a deadline, you blow a deadline. The only question is what happens there. Here, I don't think amending is blowing it at all, right? You haven't done anything wrong yet, you're amending. And so we're pleading, and we're in pleading stage, and all of those things that they're trying to keep you from doing that they should be doing, that's our only position, is you should be allowed to do all that before that. So I don't think it's consistent. It's just a question of what triggered that. And I think that shouldn't be triggered until pleading is finished. Sure.
Underlying conduct predated the effective date of the statute. Aren't you applying the isn't the city trying to apply the statute, the immunity provision, retroactively? And is that permissible?
Is it permissible? Sure. Is it within the scope of this appeal? No. The only issue in this appeal is whether the dismissal should have been properly set aside, and it wasn't. I think other cases can address whether it's retroactive application or not. Okay, thank you.
Case of Alvarez-Victoriano versus City of Waterloo is hereby submitted, and the court will be in recess until this afternoon.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.